Hello everyone. I hope you are all healthy and happy. So we are going to continue with the series of Indian Contract Act in which we have started discussing important case laws which one cannot ignore while studying Indian Contract Act. And today we are going to discuss a very important case law which is Harvey versus Facey 1893. And this case law is related to the topic of proposal. So one by one we will be covering all the important case laws as well as the provisions which are related to it and the main held portion, what was the legal reasoning which was given through this case law. So let's get into the topic. Proposal or offer. So you must have heard both the terms being used in the Indian contract topics, proposal and offer. That is because in Indian law, in the Indian Contract Act, the term proposal has been used, whereas in English law, the term offer is being used. However, both have the same meaning and both signify the same thing, right? So as we also discussed in the last class, to become a contract, to reach here, this is the process or this is the sequence which is being followed. First of all, we have a proposal. When we add acceptance to a proposal, it becomes a promise. And then when we add consideration to promise, it becomes an agreement. And every agreement which is enforceable by law becomes a contract, right? One by one we will be discussing all these terms: acceptance, promise, consideration, agreement, what is and what is not enforceable by law, and what is a contract, what are the essential elements of a contract. But for the time being, in today's video we will be focusing on proposal and the important elements of a valid proposal. So all these terms have also been defined in the different provisions of the Indian Contract Act. Section 2 clause A, it defines the term proposal. Section 2 clause B defines the term promise. 2 clause E defines the term agreement, and 2 clause H provides that an agreement enforceable by law is a contract. Furthermore, section 10 of the Indian Contract Act provides what are the essential elements for a valid contract. We will discuss all these, but today we are going to focus on section 2A, which is proposal. So it says, when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. So it is very much clear that there are two parties, person A and person B, and this person is signifying to this person, A is signifying to B his willingness to do or to abstain from doing anything. A is signifying B to do or to abstain from doing anything with a view to obtaining the assent of that other, so that he can obtain the assent of B to such act or abstinence, he is said to make a proposal. So see that there are two important elements in this definition. One is signifies, that there must be a communication between the two parties. A must signify to B that he is interested or he is willing to do something for B, and such communication must be made with a view to obtain the assent of that other. When A is signifying to B his willingness to do or not to do something, then that must be with an intention to obtain the assent of the other. right? That is when he is said to make a proposal. On the point of signification, we have already covered the case of Lalman Shukla versus Goridat in the last lecture, and today the point is of this willingness. Today the point is this, with a view to obtain the assent of other. This is our point, right? Now we will come to the case law, Harvey versus Facey 1893. For the time being, you just keep in your mind कि जब भी कोई भी एक इंसान दूसरे इंसान को अगर हम कह रहे हैं कि एक ऑफ़र बनाया जा रहा है, तो उसके लिए इट इज़ इम्पोर्टेंट दैट ए हैज़ द इंटेंशन कि वो जो भी ऑफ़र दे रहा है वो चाहता है कि बी मस्ट एक्सेप्ट इट और बी एक्सेप्ट्स इट, राइट? Why would you make an offer to someone? Because you want the other person to accept it, right? And this intention of A is very necessary, that he is making a statement to B so that he gets into an contract with him, right? So for the time being, just keep this in mind, and now let's get into the case law. Harvey versus Facey 1893 का case law है ये, and the point which was held in it is that merely a statement of price and exchange of other information is not an offer capable of acceptance, right? We will discuss it. First, let's understand the facts. So in this case, there was one property named Bumper Hole Pen. It is not a pen, it's the name of a property named Bumper Hole Pen. This property was the subject matter of this case law, and there are two people, one is Harvey and one is Facey. Harvey and Facey. So Harvey sends a telegraph to Facey asking, will you sell us Bumper Hole Pen? Telegraph the lowest price. This is the message that Harvey sent to Facey. He is asking that whether Facey wants to sell Bumper Hole Pen, and what will be the lowest price if he wants to sell the Bumper Hole Pen. Facey replies, lowest price for Bumper Hole Pen is £900. This is the reply of the Facey to Harvey. Then Harvey again replies to Facey, we agree to buy Bumper Hole Pen for £900 as asked by you. Right? This is the communication between the two parties. Firstly, Harvey sends a message to Facey that are you interested in selling your property, and tell us the lowest price for it. And then in reply, Facey is telling him the lowest price, which is £900. And then Harvey says, okay, we agree to buy Bumper Hole Pen for the £900. And now Harvey goes to the court. He goes to court and asks the court to enforce this contract. He asked the court to give the property to him and order Facey to give the property to Harvey, because a valid contract has been made as per Harvey. Now you think for yourself and try to see as per this communication whether there has been a valid offer, whether there has been a valid acceptance, because as we saw here that for a valid contract, in fact even before a contract, for a valid agreement, there has to be a proposal plus acceptance, right? Even to make a promise, there has to be proposal and acceptance. These are the two initial elements. So was there a proposal and was there an acceptance? See, when we see for Harvey, he is asking for some information, right? So we cannot say that this is an offer. He is just asking for communication, for the information about the property bumper hole pen. And here Facey is giving that information, that this is the lowest price for the property. So in these statements, we cannot say that there has been an offer by Facey. We cannot say that there was an offer by Facey, because this statement of Facey is just a general information which is being given to Harvey. He is nowhere indicating that he intends to sell bumper hole pen for 900 pounds and he agrees to, or he offers to sell it for 900 pounds. This statement, only this much of statement, does not conclude that he is making an offer, because for making an offer or for making a proposal, there has to be clear intention that the person wants the other person to accept such an offer, right? And this is what was held in this case. Mere statement of price is not an offer, and hence no acceptance was made. Mere statement of price, there was only the communication regarding the lowest price for the property, and it cannot be said to have been an offer. And since this was not an offer, this cannot be a valid acceptance. Without an offer, there cannot be an acceptance, right? This is what we wrote here. Merely a statement of price and exchange of other information is not an offer capable of acceptance. So you have to understand that in business settings, there are certain communications which are made before the parties actually intend to make an offer to each other and intend to legally come into a contract. There are various communication that take place in which the parties might ask for informations, in which the parties might inquire about the subject matter or consideration, and on the basis of that only one party cannot say that a valid contract has been made and it has to be specifically enforced now. That is not possible. And this is what is the legal point which came out of this case, that if there is only exchange of information between two people, if there is only exchange of information between A and B, then that will not be considered as an offer on the face of it. There has to be intention to make an offer. There has to be a clear indication that the information being supplied is for the matter of forming a contract. So that is it. I hope you understood this case law. I hope the facts are clear, and in the next class we will continue with the we will learn more about this point, that there has to be an intention to form a contract, and without an intention to come up into a legal relation, there cannot be a valid contract. So yeah, that is it for today. Have a nice day. Bye bye.